Court rise. The Queen on the application of Harry Miller and the College of Policing, the Chief Constable of Humberside.
My ladies, my lord, as you can see, I appear on behalf of the appellant, Mr. Miller, in this matter, assisted by my learned friend, Mr. Armitage, and Mr. my learned friend, Mr. Coppell, and Mr. Auburn represent the College of Policing. The court should have all the bundles in electronic form. I hope that they're all satisfactory. A couple of additional authorities. One was an error. We printed the wrong one off on the CAT case. And there's the additional Turkish case that hopefully the court also has. Just by way of introduction, on timing, we've discussed this amongst counsel. I anticipate being all afternoon and at about 3/4 of an hour tomorrow morning. My learned friend anticipates finishing at about 3:30, 4 tomorrow and giving me 1/4 of an hour, half an hour to reply tomorrow afternoon. We don't anticipate any difficulty in finishing the allocated time.
Good.
The court, of course, also has skeleton arguments from both sides. Before we turn to the hard-edged issues in the case, my ladies and my lord, if I can make a few background introductory comments, if I may. The court will appreciate that this is an appeal from a decision of Mr. Justice Julian Knowles to dismiss the appellant's application for judicial review against the Respondent College of Policing. It's important to appreciate exactly what it is the appellant contends in this case. He contends in this claim that paragraph 6.3 of the hate crime operational guidance, commonly known as HCOG, is unlawful in requiring that anything perceived by a victim, by any person, including what's described in the policy as a victim, requiring that anything so perceived as being a hate incident, irrespective of whether there is any evidence to identify a hate element, must be recorded as such. We say that this is both contrary to the common law and Section 6 of the Human Rights Act, read together with Article 10 of the Convention. If we can turn then to look at what we say the offending parts of the hate crime guidance are. They're in the core bundle towards the back if you were on hard copies, but it's page 495 of the electronic bundle.
Yes.
If I can just take you through the brief passages that we have in the papers, you'll see, firstly, defining hate crime, 5 monitored strands of crime, use of hate crime. One of which is transgender, which of course is the hard-edged issue that gave rise to this case. But although of course this case, it is important to emphasise, isn't just about the way in which this policy impacts on transgender speech or comment on transgenderism. It's a generic challenge to the way in which the policy as a whole operates, including transgender comments. It's important to recognise that those 5 monitored strands aren't the protected characteristics set out in Section 4 of the Equality Act. There's 9 protected characteristics that the court may well be aware. They are differently framed than these 5 characteristics. I think we have some evidence somewhere that there was a consultation that narrowed down those areas that this guidance would focus on. So they're different. For example, sex isn't one of the monitored strands, where it is a protected characteristic under the Equality Act. And so that's the 5 monitored strands. Agreed definitions we see helpfully set out in the table at the following page, 496. And you'll see there in the second box the definition of hate incident. You can see how that translates to each of the 5 monitored strands, using the circumstances as our case as an example. You see at the bottom of page 496, hate incident, any non-crime incident which is perceived by the victim or any other person to be motivated by hostility or prejudice against a person who is transgender or perceived to be transgender. And the included subjects you see on in the right-hand column: people who are transsexual, transgender, transvestite, and those who hold a gender recognition certificate under the Gender Recognition Act 2004. Pausing there, hopefully the court will have appreciated that under the Gender Recognition Act 2004, there is now a well-established procedure for a person to change their gender. That is a prolonged procedure that involves living in the other gender for a period of time, operations and medical evidence and so forth before a gender recognition certificate is issued. The court will appreciate that the nub of the dispute that gave rise to the tweets that my client sent was the consultation on proposed changes to the Gender Recognition Act, which essentially, in short, provides that a person may self-identify in a gender that they that isn't their biological gender. My client takes issue with that, as do many others, and you'll see that those people who take issue with that are often called gender critical, and we see some evidence about that from the witness statements of Jodie Ginsberg from Index, the then Chief Executive of Index for Censorship, and Professor Kathleen Stott, the professor at Sussex University. So it's not directed at people who, this provision isn't directed at people who have gone through the 2004 Act procedure. It's much broader than that. We can just go over the page. If we see it at page 498, if we can look firstly at paragraph 1.2.3, 3 points that draw attention to from this paragraph. You'll see from the first sentence: for recording purposes, the perception of the victim or any other person is the defining factor in determining whether an incident is a hate incident or in recognising the hostility element of a hate crime. So, defining factor. And then towards the bottom of that paragraph, the final sentence, the court will see: evidence of the hostility is not required for an incident or crime to be recorded as a hate crime or hate incident. Come back to that in due course, of course, as we do to the first point. And finally, for present purposes, you'll see at the bottom of the last sentence of the second paragraph: if the facts do not identify any recordable crime, but the victim perceived it to be a hate crime, the circumstances should be recorded as a non-crime hate incident and not a hate crime. So that's the dividing line between non-crime hate incidents and hate crimes. We can go over the page now to paragraph 1.2.4. You'll see that in the second paragraph of this provision, it says: it would not be appropriate to record a crime or incident as a hate crime or hate incident if it was based on the perception of a person or a group who had no knowledge of the victim, crime or area, and who may be responding to media or internet stories, or who are reporting for political or similar motive. So there's a number of clauses in that rather convoluted sentence. So firstly, not appropriate where the perception of the group had no knowledge of the victim and etc., and who may be responding to media or internet stories. So that's plainly to capture people who are commenting on stories in the national media, typically newspapers and television. and then also who are reporting for a political or similar motive. One raises, we'll come to this in due course, but while the court has that provision, there's no provision within paragraph 1.24 or elsewhere for the determination of whether those criteria are met. We also see over the page a provision at 1.2.5 relating to malicious complaints. It doesn't say that those shouldn't be recorded, it just says particular care needs to be taken. And you can see there the reference to protected characteristics, which conflates the monitored strands with the protected characteristics under the Equality Act. Not immediately apparent why. So that then is all. Finally, with respect to chapter 1 of this document, if I can take the court over to page 503, you'll see it 1.5, secondary victimisation. I can just invite the court to read that rather than read it out. So you'll see there what the guidance anticipates is that any complaints be treated with sensitivity as one would expect. But the point is that if the complainant isn't believed, then that may cause secondary victimisation and lead to additional grievance. I think that's a fair way of summarising that provision. That is another strand in this guidance which points very strongly to an uncritical acceptance of complaints being made without any investigation or inquisition as to their veracity. The majority of the hate crime operational guidance is, as one would expect, directed at hate crimes. Chapter 6, however, deals with hate incidents, and that's what's particularly pertinent in the present case. And we've got the relevant extract from page 504 over to 5007. It starts in the introduction by the definition which we've already seen. But it's paragraph 6.3 that is the hard-edged provision that we're concerned with at page 505. And if I can just read the first sentence and invite the court to read the rest in due course. Where any person, including police personnel, reports a hate incident which would not be the primary responsibility of another agency, it must be recorded regardless of whether or not they are the victim, and irrespective of whether there is any evidence to identify the hate element. And so that's a mandatory requirement. It must be recorded, regardless of whether they're a victim and irrespective of whether there's any hate element in it. And you'll see that this provision refers repeatedly to victims. So using the familiar language of the criminal justice system. Paragraph 6.4 raises the issue about public perception of this policy, and it injuncts officers not to overreact to non-crime incidents. The court see that at the fourth line down of paragraph 6.4. And then goes on in the second paragraph to refer to an appropriate response having to be compatible with Section 6 of the Human Rights Act. And you'll see that put in very general terms in that paragraph. Now, what we say about that, that is paragraph 6.4, that doesn't override the mandatory provisions that we see in paragraph 6.4. It merely, it is primarily concerned with the way in which police act. And so we see in the present case, the Humberside police overreacted in a way that was unlawful with respect to my client. There's nothing in this policy which suggests or even gives a mechanism to human rights considerations overriding the mandatory requirement to record self-perceived hate incidents.
So what do you say that first sentence means then? In what way must their response be compatible if it doesn't in any way dictate?
Well, the best answer I can give to that, my lady, is what happened in this case. And you'll see what happened was that the judge below found that the reaction of the police constable and his superiors was wrong, in that it was implying that there was a potential escalation when there was no evidence that there could have been.
In other words, it shouldn't have been recorded.
No, because what the judge below said, and this is essentially why this claim is still material for my client. What the judge said was, to paraphrase his very long judgment, comprehensive judgment, perhaps a better way of putting it, was that the policy was lawful, the recording was lawful, but the actions of the police were unlawful. So it was the way PC Gold went round to his place at work, knocked on the door, what he said, the way that the superiors dealt with my client's complaint that he subsequently made, and so forth, that was deemed to be incompatible. Now, we'll come to this in due course, but what we say is that for lots of the reasons the judge found that the actions of the Humberside police were incompatible with my client's convention rights, so too is the policy itself. And we'll see that when we come to consider interference, proportionality, and so forth. I hope that satisfactorily answers my lady's question. It's also instructive, by way of background documents, to understand how this works, to look at the crime report in this case. We've got that in the supplementary bundle at page 221. I think it's attached to one of the witness statements. It doesn't matter which one, for present purposes. And it's striking, but before we turn to look at the detail of this document, it's striking to note that my client, who made lawful comments on Twitter, as was found by the court below, is the subject of a crime report in which he is called a suspect. You'll see that in the middle of the page. And we'll see what's described as the primary offence. So the hate incident transgender is, according to this crime report, which of course remains on the record, this is the record when we're contemplating the recording, this is it. The record is that the primary offence is a hate incident against the suspect, Mr. Harry Miller, the victim's name redacted, of course. And then we see over the page the record of the interreaction between the various parties and the dates at which they took place. But this record was recorded prior, of course, to any action by the police. It was recorded automatically, as we see from the evidence. And then we see at page 224, on the 8th of February 2019, a PC Gull spoke to my client, and we see what's said about that. We've got that in all the statements of less relevance now than it was in the court below, of course.
Can you tell me something about how this is compiled? Because I see that it says finalisation type, 8 incident. Above that, investigation type, non-crime. But then we have...
Is my lady referring to the top of the...
on page 221.
Yes, yes. Well, I don't think we have any evidence, and I stand corrected, as to how this particular report was compiled, but we do have evidence in generic terms about the way these things operate, and there's an automatic system where complaints are made and they are transferred to the relevant local constabulary. There's a department there that records them as this is, and then passes it on to the local police station. So presumably it's done as an administrative task.
And it's stored locally. It said it's kept locally.
Yes.
It's not on the police national computer. That's right, isn't it?
I'm not sure about that, my lady. It's certainly used for local purposes, and different authorities, different police authorities record them in different ways. I don't know if my learned friend can assist on that point.
Yes, it doesn't go onto the police national computer in this form. If it was found that there was a crime committed, of course it would do. But in this form, the initial document, this would simply be kept on local police records.
When you say records, those are computer records stored in a computer.
Yes.
And which is searchable.
Yes. And
it would be searchable or available to other forces apart from the local one?
Not necessarily, no. The starting point is there is local police information, and then there will be protocols with regard to the sharing of certain information.
Well, perhaps we can come.
I can get more comprehensive instructions.
Thank you.
I should say, Melody, that this is a document or a template which was used by the Humberside police. It's not mandated centrally that all police forces have to use this format, as I understand it. But again, I'll get comprehensive instructions on that.
You might have one more question. You might actually look and see how this complies with the National Standard for Incident Reporting.
Yes.
The NSIR. Thank you.
There is no suggestion, however, my lady, that this is untypical of recordings nationally. Of course, the College of Policing are the respondent, in this case defendant, in the court below. And if there was something that jumped out from this document, that Humberside were doing something different than being done generally, one would have expected them to have said so. If you just bear with me one. And one of the important, deriving from the documents that we've just looked at, one of the important elements of the judge below's decision was the discretion that he said was deriving from Mr. Williams' statement that officers can use common sense to decide whether to report a non-crime hate incident. But we see that Mr. Williams says that at paragraph 11 of his statement, there's nothing in the guidance that provides any such discretion. And of course the guidance is guidance to police officers as to how they operate. If there was a discretion to inject common sense to weed out frivolous cases and so on, one would expect that to be in the policy and to be understood by those operating the policy. And of course, as we'll come to see, particularly when we're concerned with foreseeability, in any event, common sense isn't an appropriate yardstick for the quality of law to determine whether a person has a non-crime hate incident recorded against them. What one officer may think is a matter of common sense may well be very different from another officer. And of course, even if there is a scope within this scheme, which there's no apparent, and it's not apparent that there is, but even if there is, it would lead to arbitrary decision making in any event. And as we know, arbitrary decision making is inimical to lawful decision making. Two further points of background. The court will have seen what the judge below recorded with respect to my client and his background. Former police officer running a business, well educated, master's degree. I think he was a visiting professor at a local university and so forth. An intelligent man who obviously has sincere beliefs in the issue that he was tweeting about. The court will also have seen, by contrast, the way that the findings the judge below made with respect to the complainant in this case, Mrs. B. And you'll see at paragraph 280 of the judgment below that Mrs. B was operating at the outer margins of rationality, and that the terms of the complaint were on any view extreme. And we say, put shortly, that to not have to uncritically accept views or complaints of such a nature simply can't be lawful, especially in the context that we are currently concerned with, which is an active debate arriving from a consultation and a proposed change to proposed legislation. The court will also have seen that with respect to the challenge against Humberside police, what the judge below found towards the very end of the judgment, paragraph 286, was that what the actions of Humberside police did was effectively to give Mrs. B the heckler's veto to views that she didn't agree with. That phrase, heckler's veto, is taken from the Hungarian case, Vajnaj, I think it's pronounced, but the court has that. But we say, and we'll come to develop this in due course, but we say that it was not the inappropriate actions of PC Gull and his superiors that gave Mrs. B the heckler's veto. It was the uncritical recording of her complaint as required by the policy that gave the heckler's veto to Mrs. B. Two further points before we turn to the issues in the appeal for clarification. There is no objection on behalf of my client, nor has there ever been, in principle, to the recording of non-crime incidents or information, so long as they are relevant to police functions. It's self-evident that the police have the power to record non-crime incidents. They have done for very many years, and they do so under the common law powers that are available to them. What we do say, however, is that there is a qualitatively difference between the sort of information that is routinely stored by police forces and the sort of information that we're concerned with in this case. The example that was given in the court below was that there was a qualitative difference between reporting that person A, whatever the name is, was seen sitting in a car outside 23 Acacia Avenue at 1:30 on a Friday morning or a Saturday morning or whenever. Or, to link it to one of the cases we've got in the bundles, that a person was present at a demonstration, such as Mr. Catt. That was obviously lawful to record that. But they're objective facts. And the facial recognition case, the British case that we see referred to, is merely an extension of that principle. It was using modern technology, but it was just an extension of the principle of recording objective facts. But what we've got here is something very different. A non-crime hate incident, the truth of a non-crime hate incident requires an element of evaluation and judgment, not an objective fact. But what we get, what the impression that's given, what the effect of all that is that the recording of such allegations gives them an unwarranted imprimatur of authority, which to the general public, certainly a large proportion of the general public, including Mrs. B, as we see from her evidence, gives them the impression that it's correct. It plainly isn't. Now, that's a background point with respect to the recording of non-crime information by police. Second background point we make and emphasise is we recognise the importance of properly recording non-crime incidents. And in this respect, we appreciate the importance of the Macpherson report and its recommendations. But it is important to recall not just the context of the Macpherson report, we all know that, but what actually it was that he recommended, because that's somewhat lacking in the witness statements. We've got the relevant extracts in the core bundle. You can take the court to page 230 of that bundle. Before I look at the detail, recall that, of course, Sir William Macpherson wasn't here concerned with Article 8 rights or freedom of expression. He was concerned with the underlying causes of racist crime, which by extension has been translated into other areas. But if we look at his recommendations, which you see from the bottom were accepted by the, that was the Home Secretary that accepted them at the time. It's recommendations 12 and 13 that are of particular importance. We'll see recommendation 12 under the heading of a definition of racist incident, reporting and recording of racist incidents and crimes. The definition should be, a racist incident is any incident which is perceived to be racist by the victim or any other person. So that's where self-perception comes in. That's the root of self-perception. The important point is that what he recommends at paragraph 13, again also accepted, that the term racist incident must be understood to include crimes and non-crimes in policing terms. Both must be reported, recorded and investigated with equal commitment. And that's the important point. Both must be reported, recorded and investigated with equal commitment. So there must be an investigation of self-perceived racial incidents in just the same way as there is in racist crimes. Now, if the College of Policing are relying on the approach of Sir William Macpherson in the report into Stephen Lawrence's death, it has to confront the fact that as a matter of fairness and policy, self-perception has to be balanced by an investigation. Now, presumably, if there was an investigation of an incident that showed that the allegation or the complaint was trivial, ill-founded, malicious, or otherwise, then it would be expunged from the record, or the record would be adapted to say so. So a mere reliance on the Lawrence report to support the policy that's impugned in the present case simply isn't good enough, we say. Now, with those background points, we come to the hard-edged issues, if we may, my ladies my lord. You'll see that in this case, there's 5 issues that are raised. The first 2 are common law grounds. The next 3, third, fourth, and fifth, are directed at, we say, an infringement of Article 10 of the Convention. For reasons that we'll come to explain, we say that the outcome is the same in any event. But we do nevertheless maintain that it's important to have in mind the harmony that there is between the common law and the Convention jurisprudence. It's always been something that the courts have been keen to emphasise, and that the common law is developed and understood in the context of wider Convention jurisprudence. The first point, therefore, is with respect to the principle of legality. The court will have seen that the judge below rejected our submission that the principle of legality is not limited to being a tool of statutory construction. You will have read at length the cases referred to and so forth. But I don't need to take the court to all those cases because the position has now been clarified unanimously by the Supreme Court in the Miller-Cherry case. If I can take the court to that, that's in the domestic authorities behind tab 29.
Could you give the page number?
If you just bear with me one moment, my lady, I've got a hard copy. 1302.
Thank you.
This case needs little introduction, save to remind members that this was the second of the Miller cases, the one that concerned the lawfulness of the prorogation of Parliament. We aren't concerned with that issue here. But we are concerned with the effect of the exercise of the common law power to prorogue Parliament, prerogative, on fundamental constitutional rights. The judgment, as the court may recall, and you'll see, we got the it's a unanimous judgment of the court, the judgment itself being that of the President and the then President and Vice President, Baroness Hale and Lord Reid. See that at 13223. Leaving out the background that isn't necessary for present purposes, if we can take the court to to page 1335. Just before we come to the highlighted parts, if I can take the court to paragraph 47, as the constitutional principle that the court is concerned with in the subsequent paragraphs is the principle of parliamentary accountability. And at paragraph 48, you'll see that the Supreme Court said that principle is not placed in jeopardy if Parliament stands prorogued for a short period, which is customary. And as we've explained, Parliament does not in any event expect to be in permanent session. But the longer the Parliament stands prorogued, the greater the risk that responsible government may be replaced by unaccountable government, the antithesis of the democratic model. So the same question arises in relation to parliamentary sovereignty. What is the legal limit upon the power to prorogue, which makes it compatible with the ability of Parliament to carry out its constitutional functions? And then we get the relevant paragraph. Can I invite the court to read paragraphs 49 and 50? So you'll see from paragraph 49 that it says, perhaps a statement of the obvious, starting the second line from the top. The prerogative power is, of course, different from a statutory power, since it is not derived from statute. Its limitations cannot be derived from a process of statutory interpretation. However, a prerogative power is only effective to the extent that it is recognised by the common law. As was said in the case of proclamations, the king hath no prerogative but that which the law of the land allows him. Prerogative power is therefore limited by statute and the common law, including in the present context the constitutional principles with which it would otherwise conflict. So then we see then that's a marked departure from the hitherto understood a proper understanding of the principle of legality. And then at paragraph 50, the court goes on, for the purposes of the present case, the relevant limit upon the power to prorogue can be expressed in this way, that a decision to prorogue Parliament or to advise the monarch to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification. We'll come back to that qualification in due course. If it does so, if it frustrates or prevents the ability of Parliament to carry out its constitutional functions as a legislature, etc. In such a situation, the court will intervene if the effect is sufficiently serious to justify an exceptional course. Now, my learned friend's response to that in his skeleton is to say that, well, this is an exception, that Military was an exceptional case and is of no general application. But you'll see from our skeleton that we refer to learned commentary on this judgment, which supports our case. It's the article from Professor Mark Elliott that we've got in the bundle, and we see that behind tab 46, starting at page 1822. If we can take the court to that. I don't think Professor Elliott needs any introduction. His eminence is, of course, well known and respected. I'd invite the court to read this relatively short article in full in due course, but if I can just pick out some important features. At page 1828, Professor Elliott provides the heading, A New Approach to the Standard of Review and the Principle of Legality. So you can see we're straight away into the Principle of Legality territory.
How far do we go with this? I mean, this is academic commentary, of which there was an enormous amount on this particular case.
Yes.
And we have, we're guided by the decisions of the court.
Absolutely. What we're saying is that what the Supreme Court said in Miller Cherry, paragraphs 49 and 50, is entirely consistent with our case, and that's supported by what Professor Elliott's analysis in this article, my lady. Mm. Much of the commentary that your ladyship's absolutely right. There was an enormous amount of commentary on this case, but actually very little commentary on its legal implications.
Well,
for the development
we're determining what the implications are of the court's decision, and no doubt other academics would have a different point of view, but we're not here to arbitrate on academic opinion.
Absolutely not, my lady. So far as we're aware, this isn't controversial in any event, although I may be wrong. I'm not aware of any academic commentary to the.
Well, show us the part you want to rely on.
I'll be as brief as I can, my lady. 1829.
Yes.
I can just invite the court to read the first section. However, the court avoided any such problem by the effect, etc. But the really important section is the section that's sidelined. This does not break entirely new ground, but does mark a significant extension of the principle of legality. In El Ghazouli, and you'll see that was referred to in the court below and by the court below, the divisional court sought, wrongly in his view, to confine that principle, that is the principle of legality, to an interpretive one that therefore applies only to legislation. In Cherry Miller number 2, the Supreme Court made it plain that the principle of legality is a principle of much broader application.
Well, this is a proposition that you're going to have to found on the wording of the decision of the Supreme Court.
Yes, absolutely, my lady. And we hopefully we did that very briefly by saying that the prerogative powers that were referred to by the Supreme Court are common law powers, just as are the common law powers of the police to record information. More generally, weighed against that. Sorry, Miller.
Sorry to interrupt. Miller doesn't refer to the principle of legality.
No, it doesn't.
At all.
No, it doesn't. But what it does do, and this is why I was anxious to draw this out, if you look, my lord, at page 1336 of the report, you'll see the sentence in the second line. A prerogative power is, of course, different from a statutory power since it is not derived from statute, etc. And the court, Lady Hale and Lord Reid go on then to say why the common law, why it's a creature of common law, that it's a creature of common law, and subject to what in effect is the principle of legality. It can't override constitutional principles unless, as we see in the next paragraph, there's reasonable justification. So we got the common law power here to record information. Common law power vested on the police. Counterbalanced against the fundamental right of freedom of expression, which, as we know, is the lifeblood of democracy, and an important fundamental right. We're in very similar territory. Not the same, obviously, but we're in similar territory. And Professor Elliott supports that. Firstly, El Ghazouli is plainly no longer good law, because the Divisional Court in El Ghazali said that the principle of legality has no traction with respect to prerogative powers. Well, that's directly contrary to what the unanimous Supreme Court found in Malicious. And of course, Professor Elliott then goes on to understand the and set out the necessary implications of what the Supreme Court said in that case. So if I can just go on quickly to two more parts of the article. If we can pick it up at page 1831, in the concluding part of Professor Elliott's article. He makes clear that this approach is only available when fundamental principles or rights are in play. Well, that naturally follows. The principle of legality only applies in those circumstances. And towards the bottom of the page, it says it undoubtedly represents an important milestone in the narrative arc of modern public law in the UK. And then if we go on to page 1832, he refers in the paragraph starting, what then are we to make of this case? If we look to about 2/3 of the way down that paragraph, that is the divisional court in Military, to the sloppy argument that because the issue had political implications, it could not at root be a legal matter. Then, importantly, it goes on, it extended the principle of legality such that it now falls to be understood, as it always should have been, as a mechanism for giving concrete legal effect to fundamental constitutional principle, irrespective of whether the legal powers at stake are conferred by legislation or arise under the prerogative. And that's the point. So, our short point on this first ground of appeal is that the judge below was wrong to say that the principle of legality is only a tool of statutory interpretation. It is a tool of statutory interpretation, but it's not limited to being a tool of statutory interpretation. That's the short point. We don't need to take the court to the plethora of cases that came before Military. The unanimous...
How would you articulate the principle that you say should be applied?
That the common law can't undermine or frustrate the fundamental rights of citizens without, let me just get the correct phrase that Supreme Court used, without reasonable justification.
What does that mean?
Well,
though?
that was the next point I was coming to, my lord. This is where we get the commonality with the convention jurisprudence, my lord. So what we say is that the common law has now recognised the same essential structure as the Article 10 jurisprudence.
When you said you started this part of your argument by saying that this is the arrives at the same outcome.
Yes.
What does this argument add to your argument under Article 10?
Well, it doesn't. Nothing, save that it makes clear that the common law is in harmony with the convention jurisprudence. And that's something that the courts have always been anxious to emphasise.
If you're right about this kite that Professor Elliott is flying, without being pejorative about it, it would overturn a great deal of established law, would it not?
Yes. It's a milestone in public law, as Professor Elliott says. But it's not inconsistent. It does overturn very many cases. Of that, there's no doubt.
In your submission.
But it goes, yes. But it goes back to a principle that Lord Hoffman articulated many years ago when he was an LJ, sitting in this court. It was a family judge. Oh no, it was the Central Television case. We've got that in the papers. In fact, we relied on it in the court below. It's behind tab 14.
You'll have to give us a page number.
I will, just bear with me one moment, my lord. It's, 622. As its name implies, this was a broadcasting case. Lord Justice Hoffman, as he then was, his speech or the judgment starts at page 632, my lord and my ladies. You'll see the sidelined paragraphs, but the point is expressed with characteristic robustness by Lord Hoffman at page 633 at B. It means the right to say things which right-thinking people regard as dangerous or irresponsible. This freedom is subject only to clearly defined exceptions laid down by common law or statute. Now, it may be that at that time, we're 1994 there, that the parameters of the principle of legality hadn't been debated to the extent that they subsequently were. But that was Lord Hoffman's view before the subsequent cases. He was right, and we've come full circle to, and the Supreme Court has now unanimously recognised that. And what that also means, what's also important, because it's very important in the analysis of Military, given its context, that if there's no justification at all for the infringement on the fundamental right, then one doesn't get into the territory of reasonable justification. And that's what happened, and that's why Professor Elliott talks about this, the principle being a question of vires rather than reasonableness. The Supreme Court didn't get into reasonableness in that case. And we say there's a similar parallel in the present case. That these are what we say are offending provisions, don't have the quality of law, such that we even get to have to consider whether there's reasonable justification, proportionality, and so forth. We say that there isn't in any event. But one sees the one sees the harmony, the way in which both the common law and the convention law work hand in hand.
Are we bound by the authorities on this point, saying it is simply a question of statutory construction, a tool of statutory construction?
This court can't be in the light of Military, my lord, not in our submission.
You have to bring in, Jerry, to unwind all this.
Yes. We say it was implicit in unison in the other cases, but we don't need to go there now. Of course, Military came out after we were pretty certain it was sure it was after the. No, it wasn't. But I'm not sure when the judgment was handed down. In any event, that clarifies the Military clarifies the law. Unanimous decision of the Supreme Court. That's what binds this court, my lord, on ordinary principles.
Even though it doesn't mention the principle of legality, but you say by analogy,
yes, it
overturns all these other cases.
It must be. I mean, one has to be very careful, as I'm sure your lordship is, and we all are, with labels. We have to understand what's meant by the principle of legality, and if one unpacks it all, one sees quite clearly how it relates to what the Supreme Court said in Military. The only radical departure, and one of course must be careful because these are constitutional principles. We say that it makes no difference, but of course the language of Military was all to do with the prerogative and the prorogation of Parliament. Now, being devil's advocate and arguing against myself just for one moment, just in order to answer my lord's question, it could be said that the prerogative powers are distinct from common law powers generally. But in our submission, that argument just simply can't wash, because prerogative powers are common law powers. It's impossible to see why they should be any, by what principle they could possibly be any different. And it makes sense in our submission. Why should it be that the constitutional imperative to ensure that the fundamental rights of the citizen are protected only applies when the courts are considering issues of statutory construction and not the common law? If there wasn't a common law power, perhaps put it in a slightly different way. If the police didn't have a common law power to collect the information that they do, it's inconceivable that there wouldn't be a statutory power that provided them with that power. Inconceivable in our submission. A modern police force couldn't work without being able to do that, and I'm sure that's an international. Sure, there's an international parallel with all that. By the happen chance that the law happens to exist in any event as a matter of common law, it doesn't have to be into statute. That can't be a good reason for not protecting the fundamental rights of the citizen in the same way.
Yeah, I'm sorry, maybe I'm being very slow. I just don't understand this. The principle of legality is about parliamentary sovereignty. When Parliament enacts a statute,
well, that's when it's
the courts must abide by the statute, unless it can be said that there's a clash between the statute and fundamental rights, and it's not clear from the statute that Parliament confronted those rights. We're miles away from that.
That's the way it's been interpreted in a number of cases, my lady.
So I don't see where Miller-Cherry gets you.
Well, where it gets us is that the common law can't. Doesn't matter how you describe it, but we say it comes to the same thing. The common law can't undermine the fundamental rights of the citizen without there being a reasonable justification for doing so.
But
it comes to the same thing.
That's circular, isn't it? You're really saying the common law can't undermine the common law.
Well, not necessarily, because well, yes, it may. Your lordship has a point. Yes, that may well be right, but that's rational. Why shouldn't it say that?
Because it's circular.
Well, not necessarily, because that other common law powers aren't exercised in a way that conflicts with the fundamental common law powers that underpin the rule of law generally.
Because you've told us that prerogative powers are common law powers.
Yes. Yeah. What we say is entirely consistent with what the Supreme Court said. But as my lady recognises, we get to the same result in any event. This is obviously a fertile legal argument that will have to be resolved. Will inevitably have to be resolved at some point, whether it's resolved in this case or another.
You're certainly on more conventional ground in your Article 10 arguments.
Yes, yeah. But there is, before I leave it, but there is plenty of jurisprudence, particularly from the Supreme Court, and one thinks about cases such as Osborne, where Lord Reed gave a judgment which where it was a prisoner's rights case. I wasn't involved in it. It was 2 or 3 years ago, where there had been argument over 2 or 3 days about convention jurisprudence. They'd cut through all this. These are just common law principles, and these issues should be addressed in ordinary common law terms. So different courts take different views, but there is certainly authority to suggest that the primary focus of the court should be the common law. But it's a matter for the court how they...
It was always said that freedom of expression is a common law principle of enormous importance.
Yeah. And that's how it got into the convention, of course, because it was a common law principle of our society. We put it there, didn't we? Of course. But anyway, there we are. The court has the argument. We say it's a good one. My learned friend doesn't. but we'll pick up the without reasonable justification and via raise points under the rubric of Article 10. The second ground of appeal is that it's unreasonable for the hate crime operational guidance to require recording of hate incidents regardless of whether there is any evidence of hate. The judge, as the court will see, didn't address this directly. He merely said that he'll address it under the under proportionality. That's it.
And if you're right that the common law argument doesn't add anything to the Article 10 argument, you can't really quarrel with his approach, can you?
On this point about the absence of hate.
This is part of your common law argument, and I thought you said earlier that the common law argument doesn't add anything.
Sorry, what I meant then, and perhaps it was my fault for being a little sloppy, the common law argument with respect to the principle of legality comes to the same as the Article 10 point. It may well be that this point gets subsumed by the Article 10 arguments as well. But that doesn't mean that it isn't a good one. And, of course, if contrary to our submissions, the court isn't with us on Article 10, then this point is a good freestanding one, frankly. This is a straightforward rationality challenge of which the courts are very familiar. One only has to just recite the terms of the policy, we say, to show how irrational it is. It must be recorded, paragraph 6.3, the court will recall, it must be recorded irrespective of whether there's any evidence to identify the hate element. And we say that defies common sense in the most basic Wensbury fashion. How can we have a non-crime hate incident where there's no evidence of hate? It simply defies any common sense. Now, impossible to understand how that can arise. Now, as you see, the court below didn't deal with this point, and in their skeleton arguments, the respondents, we say, misconstrue this challenge as being a challenge to self-perception. But that's not the case, because just because the allegation is based on self-perception doesn't mean that there doesn't have to be some basis to support the perception of a hate incident. One can respect a person's particular perspective on an incident or writings or so on. But there has to be an element of hate to justify recording it as a hate incident. So, I mean, to demonstrate the point, if I can give the court a couple of examples. Take, for example, a person like Mrs. B operating at the outer margins of rationality, who somehow thought that tweets or other communications about the weather were hateful. A situation where there's no hate, no evidence of hate whatsoever. Under this policy, that has to be recorded as a non-crime hate incident. Mandatory 6.3.
Is
must
that
be
what
recorded.
the judge said? I mean, the judge, I think, took a slightly more nuanced approach to this issue.
Well, the judge was enamoured by Mr. Williams's point at paragraph 11 of his statement that the police will inject common sense into whether to record a non-crime hate incident. But there's nothing in the policy that says that. And there's no evidence that the police ever do that. Now that's perhaps an extreme example where tweets about the weather are considered somehow to be hateful, but not inconceivable if a person's operating irrationally. But take a different example, which is which would also be very troubling. Supposing a citizen tweeted or communicated in some way something that was intended to be positive to one of the protected strands, and it was misconstrued, it was misunderstood, and it was thought to be hateful when in fact it wasn't hateful at all. And this happens. People perhaps don't express themselves clearly, or people misunderstand for whatever reason. But again, a communication, a lawful communication that supports the groups that this policy is intended to support, would then be recorded against that person as a non-crime hate incident. It's completely irrational, we'd say, and it's not good enough to respond by just saying the police would exercise their common sense.
You would describe that as a non-crime, non-hate incident.
Pardon? A non-crime, non-hate incident. Well, it's nothing to do with the police, frankly, and that's why that's the importance of freedom of expression, of course. In this country, we're free to do what we want, unless there's a law against it, of course. And these issues are very important, especially given the new social media environment that we're now living in.
Sorry, Mr. Wise, you've said that the policy doesn't allow for a decision not to record, but the judge actually found that 1.2.4 and 1.5 delineated circumstances in which a complaint would not be recorded.
Yes, I was going to come to that.
Oh, sorry.
Milady. No, well, I'll deal with it now. Take it head on. Can you remind me the paragraph number, Milady?
In the guide, 1.2.4 and 1.5, and it's paragraph 209 of the judge's judgment.
Yes, that's right. Can we go back to the... let's just be absolutely clear what the judge said about it first. He was saying that that delineated...
circumstances in which a complaint will not be recorded.
Okay, so we looked at these two. This is why I took the thought to these provisions at the outset, of course, because it comes up in the judgment. We look at paragraph 1.5 first, because that's the more straightforward one. That's at page 503 of the core bundle. This is concerned with secondary victimisation. The court will recall me taking me to that at the outset. It has nothing whatsoever to do with the circumstances in which a complaint won't be recorded. It merely says that a complainant should be treated with sensitivity. The police be mindful of the possibility of a complainant being doubly aggrieved by not being believed. Completely wrong. The judge got that completely wrong in our submission.
Can I add, Lady, it seems to us that the judge meant to refer to 1.2.5 rather than 1.5.
Yes,
absolutely.
Yeah.
Oh, right. Right, I'm sorry. I hadn't appreciated that was the case. Right, okay, well, if we can turn to that provision then, malicious complaints, page 500 of the guidance. This is dealing with celebrities and political figures. It doesn't address the scenario that I posited just now, which is an everyday scenario that could well affect many thousands of citizens. This is a more restricted group of people, celebrities and political figures. But it doesn't say anywhere that you wouldn't record.
We're reading it backwards. Sorry, Mr. Wise. We're reading it backwards. Shouldn't we be starting at 1.2.4 or indeed 1.2? Because 1.2.4 talks about it not being appropriate to record.
Yes. Okay, well, absolutely. Where would your ladyship prefer me to start?
Well, 1.2.
Okay. Again, very limited circumstances, it would not be appropriate to record in those circumstances. And I'm pausing there, it's the point that I made at the outset. How do they know that these conditions apply. There's no requirement for an investigation. How would they know? There's nothing in this procedure that requires an investigation. If there was a requirement for an investigation that looked at the veracity and impact of these messages, then we probably wouldn't be here, to be frank, because any investigation of the most cursory kind, who looked at my client's tweets, would have dismissed it out of hand, not recorded it, and not followed it up. But that doesn't happen. So, and the judge said, if 1.2.4 had been properly applied, my client's tweets probably wouldn't have been recorded. But the point is that there's no procedure within the rule, within the policy, to see if it is appropriate to record any such allegations. And you see that, and also 1.2.4 is in very limited circumstances. If you unpick the primary paragraph, starting it would not be appropriate, you'll see it's not appropriate where it's based on the perception of a group or had no knowledge of the victim, crime or area, and who may be responding to media or internet stories. Pause there for a moment. So this is in response to, this is communications in response to media or internet stories, typically something on television or in the newspapers, or reporting for political or similar motive.
But one of the interesting things about this paragraph is that it applies to what would be regarded as a hate crime and a hate incident, which is not a crime.
Yes.
So it's seeking to cover both.
Yes.
Well,
this is in chapter 1.
Yes.
Yeah. Well, that's the point. When we're particularly concerned with non-crimes, hate incidents, where it's lawful conduct, but nevertheless the police take action. So 1.2.4 says that that delineates. Sorry, just to go back to his language that my lady referred to. Sufficiently clearly delineate the circumstances in which a complaint won't be recorded. Well, 1.2.4, subject to the issue about how do we know that these criteria are met, it is only applicable in very limited circumstances anyway. He says that 1.2.5 has the same effect. Sufficiently clearly delineates the circumstances when they won't, when communications won't be recorded. But 1.2.5 doesn't say that at all. Even under the heading of malicious complaints, it doesn't say that malicious complaints won't be recorded.
Well, isn't that the necessary implication?
It doesn't say so. I mean, it says so in explicit terms in 1.2.4. But one has to look at this in the context of what it says at paragraph 6.3. Makes absolutely crystal clear. In the chapter that is concerned, the chapter of the guidance to police officers that's concerned with the responses to hate incidents, it says that an allegation must be recorded regardless, irrespective of whether there's any evidence to identify the hate element.
What do you say about the second paragraph of 1.2.5?
1.2.5?
Yes.
Sorry. Well, that goes to the point that we see on a number of occasions.
The second sentence in particular.
It's important not to falsely accuse an innocent person. Well, of course. So, a policeman shouldn't go to a knock on the door and falsely accuse an innocent person of something. But that doesn't mean that it's not recorded. But again, one comes back to the fundamental issue, the problem with 1.2.4. There's no investigation. of the allegation. And how do we know whether it's a malicious complaint? How does anybody know whether it's a malicious complaint or not? Open season. So that took me slightly out of my train, but I was going to come to that in due course. Anxious to deal with my lady's point in any event. Hopefully that deals with that point. And of course one has again to have very clearly in mind, not just this isn't irrationality in a vacuum, of course. This is, never is. In these circumstances, it's in the context of the fundamental right of freedom of expression. And in those circumstances, the court will apply a most rigorous approach to the rationality of the provision. It's simply irrational, and there's no sensible answer to it. But this aligns with to show how the dangers of this. We see that the dangers are apparent from the facts of our own case. But to show the more widespread dangers of that, can I take the court briefly to, as we took the court below, to the report of Sir Richard Henriques in his review of the Metropolitan Police's handling of the non-recent sexual offence investigations. We've got that starting at page 1738 of the papers. Page 1738, the scope of Sir Richard's report. See in the paragraph in the middle of the page, Sir Richard's subsequent report examines 8 Metropolitan Police Service investigations. He outlined serious failings in Operation Midland, Chapter 2 allegations made by Carl Beach, aka Nick, and Operation Vincente, investigation into an allegation from a different complainant, allegation alleging rape by Lord Britain. And the court will, of course, remember all those, but we don't need to go into the full report. But if I can just take you to the recommendations, the rationale for them are set out in more detail. But if we can go firstly to page 1756. You recall that Sir Richard was very critical of the Metropolitan Police, the way they handle these investigations. His first recommendation was throughout both the investigative and judicial process, those who make complaints should be referred to as complainants and not as victims by the Metropolitan Police Service. Well, we see here that the word victim is used. But more importantly, it's the police section, and this derives, as you see, from the College of Police policy. You see at 1.21, at the point when somebody makes an allegation of crime, the police should believe the account given and a crime report should be completed. Now,
how does this help us on what we are looking at here?
Because it shows the very real dangers of an approach where there's an uncritical belief in what a complainant
well, that's an argument you can make on the basis of the document and the policy we're considering.
Well, this is the College of Police's guidance, which is in similar terms to the guidance that we're considering, Milady. But in any event, what he drew attention to, if I can put the point briefly, in any event, he said that such an uncritical acceptance of what a complainant says is the wrong approach unfair and leads to unfair outcomes. There should be an investigation of the complaint objectively and impartially with an open mind at the outset is what the recommendation is. And then, of course, he goes on to deal with false complaints. There should be an awareness that from time to time false complaints are made. It's recommendations 2 and 4 of Sir Richard's report. So very serious consequences in not having a rational policy that requires complaints to be properly understood and investigated. And that factors in both to the common law challenges that we raise in this case, and why the court below was wrong to not find this provision to be contrary to common law due to irrationality. But it also factors into the Article 10 argument, in particular when one's considering fair balance. And that will obviously be immediately apparent to the court. So those then are the common law challenges. We then turn to the Article 10 challenge. I don't need to take the court to the terms of Article 10. That they will have, that the court will have that. We've got our submissions on this in our skeleton argument starting at page 16, paragraph 36, where we identify 3 errors on the part of the judge in finding that that the impugned provisions of HCOG didn't interfere with Article 10 rights. So firstly we say at paragraph 37 that the judge, having correctly recognised that the Strasbourg court has a very broad understanding of what constitutes an interference with freedom of expression, including whether the state activity indirectly limits expressive activity. So the judge correctly recognised that, and then accepted that the recording of a hate incident may be disclosed on an enhanced criminal record certificate. And we see that in paragraph 183 of his judgment. He nevertheless found that the low threshold for interference was not met in this case. He was wrong to do so. The very low threshold for interference was plainly met in this case, even on the judge's own findings. But then we go to paragraph 38. The court will see that we contrast the approach the judge took with whether the policy interferes with Article 10 rights, with whether the actions of the police in this particular case interfered with the Article 10 rights of my clients. So if we look at paragraph 241. Sorry, 54. My mistake. Page 125 of the core bundle. The court will appreciate that the judge went through this exercise twice. He went through it with respect to the policy and then with respect to the practice of the police. We're looking here at interference. I apologise, my lady.
Which paragraph of the judgment?
254, page 125, lady.
Yeah. I've got mine on 126.
Me too.
Oh, sorry. Not quite sure how that's happened. You'll see at 254, the judge quotes from Clayton and Tomlinson's textbook on the law of human rights. And you'll see the extract that he says, interference can take a variety of forms, and the court has generally considered that anything which impedes, sanctions, restricts or deters expression constitutes an interference. But of course, that also applies. That applies to the policy just as much as it applies to the individual actions of the police. Now, having recognised there that anything which impedes, sanctions, restricts, or deters expression constitutes an interference, having found that there's a real possibility of disclosure of a non-crime hate incident on an enhanced criminal record certificate, it's just impossible to see how the judge could arrive at the conclusion that he did with respect to the policy.
Leaving aside the risk of disclosure for a moment,
Yes.
looking at the broad terms that Clayton and Tomlinson
Yes.
define this, and particularly what might deter expression, does in your submission, the recording of this in this manner, does that act as a deterrent?
Yes.
And why?
Because it's the recording that could be. Oh, sorry. Leaving aside the.
Leaving aside the.
Well, we see that from the evidence itself. What Mr. Miller and his wife say. His wife's very trenchant and makes two very trenchant statements about the impact that it has on her. And indeed, can I make the point good by reference to the judgment? If you look over the page, it's my 126, maybe your Lordship's 127, paragraph 257. You see the extract there that the judge provides from paragraph 40 of my client's witness statement.
Your point is it's the manner of the recording as a hate crime. This is a suspect,
Yes.
quote unquote,
Yes.
in a police criminal database.
And frankly, my client's reaction, we would suggest, is no different than any ordinary member of the public. Perfectly reasonable reaction. None of us want to have matters recorded against us on police databases and be labelled as potential criminals or whatever.
This is the chilling effect that you're
Course it
talking
is.
about here.
And what that paragraph expresses my client's chilling effect. But what the judge has done there, I'm not quite sure why he's done this, but can I take the court to the paragraph as a whole? Because he misses out the beginning, the first part of the paragraph. It's at page 9 of the supplementary bundle. Now, what the judge says, however, I accept that what that's my client, said at paragraph 40 of his witness statement about what he felt following his conversation with PC Gulf. I felt a deep sense of both personal humiliation, etc. But what he actually says at paragraph 40, as I realised that my name would be recorded under incidents marked hate, and that this incident would contribute to a set of statistics marked hate crime incident, I felt a deep sense of both personal humiliation, etc. So the judge, for some reason, misses out the first part of the sentence. That paragraph wasn't related, as the judge says, to a reaction to what PC Gull had done, the knock on the door and so on, albeit that that's obviously important. It was the fact of recording. And that gets to directly to my Lord's point. What is the impact on this individual? And, and presumably, by extension, is it a reasonable reaction? And we have it there. We have it there.
Is your general broader point that the apprehension of the recording of this would have a chilling effect societally?
Well, it would have a chilling effect on freedom of speech generally. That's the point, my Lord, isn't it?
Because we would all be at risk,
Yes.
say, of this potential recording.
Yeah, a real risk, and that's the language that the courts use. Well, I'm going to come to that in a moment. But to similar effect, we also have Julie McGowan's statement. Julie McGowan's Mr. Miller's wife. Can I take the court to that? That follows on in the supplementary point. It starts at page. She gives two very short statements. If I can take my ladies and my lords to them. It starts at page 20. She starts off at page 20 in the first couple of paragraphs by expressing her interest in this issue. But then she goes on over the page, paragraph 4 onwards, to deal with the interaction of a husband with the police. And you'll see from paragraph 5 onwards the impact it had on the family and the daughter. The daughter was a police officer. She was asked by the police whether she agreed with her father. It's quite astonishing. I mean, these are perfectly lawful communications that my client's making.
So there was a dual approach, one directly to Mr. Miller and one to the daughter.
Well, there's an impact on the wife as well, of course.
And to Mr. and Mrs. Miller, and then
Yes.
separately
Yes.
an approach,
Yeah.
physical approach
Yeah.
to the daughter, at least contact.
And then Mrs. McGowan makes another statement. We've got that at page 50. And can I invite the court to read paragraph 2 of Julie McGowan's second witness statement at page 50 and over to 51 for the supplementary one.
Which paragraph did you say?
Paragraph 2, my lady. Again, we would say a perfectly rational reaction, and on any reading, we say clearly passes the low threshold for interference with an Article 10 right. The broader point we were making at this juncture, the court will recall, was that the judge below adopted conflicting approaches to interference with respect to the policy and with respect to the actions of the police. And the rigorous approach that he adopted with respect to the police service, the Humberside police, should properly have been applied to the policy. And if they had have done, he would, if he had done so properly, he would have found that threshold was in fact met. And the rationale, one of the rationales for the judge's finding on the second, against the second defendant in the court below, we see a paragraph 259, page 126 or 127 of the court's bundle. Counsel for the defendants both sought to play down the police's actions. They said that there had been no interference with the claimant's free expression rights, or if there had, it was at a trivial level. In my judgment, these submissions impermissibly minimise what occurred and do not properly reflect the value of free speech in a democracy. Well, the judge is absolutely right about that, of course, and he goes on with the descriptive language in the last sentence of that paragraph that the court sees. But that analysis applies equally to the policy as it does the actions of the police. What the police are seeking to do is impermissibly minimise its impact, and it doesn't properly reflect the value of free speech in a democracy.
Are you going to take us to the passage where the judge explains the difference between what might be called the policing and I think what's described by Mr. Coppell as the administrative action of recording?
Which paragraph does your ladyship have in
Well, I was
mind?
rather hoping you would be able to tell me.
If you bear with me 1 moment.
(177), I think that's where it starts.
177, my lady.
I think so. I might be wrong.
Yes, that's it.
Well, that's the point that 177 is the point that I've already addressed the court on. Mr. Williams saying it's just administrative. They've got the discretion. Police have the discretion to exercise common sense. But for the reasons we've already said, we say he was wrong about that. Yes, at 176, I apologise. Yes, I recognise the four lines at the bottom. I recognise the argument that the mere active recording speech may have a chilling effect on the speaker's right of freedom of expression, but in my judgment, the mere recording without more is too remote for any consequences that it can amount to a handicide restriction. But in our submission, that's a non sequitur. Especially with respect to interference, which, and of course this is in this passage of the judgment is in respect to that. If the act of recording speech may have a chilling effect on the speaker's right of expression, it's inconceivable, it's simply not understood how that can be too remote from the consequences that it can amount to what's called a handicide restriction. Now the handicide restriction, I think he deals with earlier, it's paragraph 49 of handicide. But handicide, I mean, that's just a general description of the type of things that may constitute an interference. Bear with me 1 moment. Look, somewhere he actually sets that out. But once. Oh yes, sorry, I'm reminded from behind. The third line of 176. So it did not amount to a formality, condition, restriction or penalty, what he describes as the handicide restrictions, etc. But of course, if we can look at handicide itself, that doesn't properly characterise what the court said even those many years ago. Got handicide in the papers at tab 7. I'll give you the electronic number in 1 second. 341. And paragraph 49 of that judgment is where that rubric comes from. It's page 358 of the bundle. You see, this is a 1976 case. It's an Article 10 case. This was concerned, this case, the court may recall, was concerned with the Obscene Publications Act. It was a book that was circulated for children. See my lady nodding. Notorious at the time. But for present purposes, all we need to do is look at the bottom 4 lines of page 358. This means, amongst other things, that every formality, condition, restriction, or penalty imposed in this sphere must be proportionate to the legitimate aim pursued. So the court isn't restricting. It isn't restricting the parameters to formalities, condition, restrictions, or penalties. Not only in those circumstances that there'll be an interference, amongst other things, it's just a general comment. So what is unquestionably clear, as the judge appears to recognise, especially with regards to the second defendant in the court below, the threshold is very low indeed. So we would say that rationale at paragraph 176 is deeply flawed. Now, finally, the court's been provided with copies of the Turkish case, which you should have now behind the last tab. Unfortunately, it isn't paginated. I don't know if you have this freely or in soft copy. This again was an Article 10 case. Court sat at the judgment was given in 2011, but although the case only reported in 2016. So fairly recent. And you'll see from the head note that this case concerns a provision in the Turkish Criminal Code, Article 301, which criminalised denigrating Turkishness. See that from the very first paragraph of the head note. Mr. Akam was a professor who specialised in the Armenian genocide and had written extensively about it. And that's a matter of considerable controversy, of course, in Turkey, and Turkish nationalists take a very strident view as to those who, like Professor Akam, who attribute responsibility to the Turkish state for what happened in I think it was 1915 in Armenia. So he was a respected academic with controversial views. Now, what we see from the circumstances of the case, picking it up if I can at paragraph 8, you'll see that a complaint was lodged with the regional public prosecutor. The complainant, a member of the public, alleged as we see, made the allegement of acting contrary to various provisions of the Turkish Criminal Code. At paragraph 10, we see, and this is you see the sideline paragraph, the investigation against the applicant was terminated by the local public prosecutor, who noted that all the scientific seminars he had taken part in and his publications, the applicant had expressed the opinion that the events that took place between 1915 and 19 could be described as genocide. Having examined the applicant's article published in Agos, the public prosecutor concluded that the applicant's statement in his capacity as Professor of History came within the realm of protected expression under Article 10 of the European Convention on Human Rights, and as such they did not constitute denigration of Turkishness. So that was where, so far as the Turkish authorities stood, the matter was left. But nevertheless, Mr. Akam brought this claim in the Strasbourg court against claiming that Article 301 of the Criminal Code was a infringement of his Article 10 rights, regardless of the fact that that any prosecution had been withdrawn. And what the court does is then, firstly, to examine, and we get this at, well, we pick this up at paragraph 53, page 442 of the report, alleged violation of Article 10. As you just said, Mr. Akam complained, the existence of the article in the Turkish Code interfered with his right to freedom of expression, he maintained that the mere fact that an investigation could potentially be brought against him under this provision through scholarly work on the immediate issues causing great stress, apprehension, fear of prosecution, etc., and thus constituted a continuous and direct violation of his rights under Article 10, which reads as follows. And then the government the government contested that there had been any interference, perhaps not surprisingly in the circumstances. And then we get to the court's assessment, having set out the respective arguments. We see at page 445, the court set out its assessment on interference. And can I invite the court to read paragraph 67 through to 70, noting particularly paragraph 68. So you
Yes.
and then against that narrative, the court concluded, as we see at paragraph 75, page 447, the court considers that while the applicant was not prosecuted and convicted of an offence under Article 301, the criminal complaints filed against him by extremists for his views on the Armenian issue had turned into an harassment campaign and obliged him to answer charges against that provision. It therefore be accepted that even though the impugned provisions have not yet been applied to the applicant's detriment, the mere fact that in the future an investigation could potentially be brought against him had caused him stress, apprehension, and fear of prosecution. The situation has also forced the applicant to modify his conduct by displaying self-restraint in his academic work, etc. And one immediately sees, therefore, the wide breach, the wide berth that interference is given by the court. So even in a case that would appear academic, the possibility, the risk, is the word that's used in paragraph 68, risk of being directly affected is sufficient for there to be an interference.
Can I just ask about the mechanics again? The fact that the police record doesn't mean that an individual is spoken to.
No.
And what do you say about a mere recording as opposed to a situation in which an individual comes to know about the fact that a non-crime hate incident has been recorded? Or has been
Is your ladyship positing the situation where a record is made that the person complained about doesn't even know about it?
Yes.
Yes. Well, of course, the individual has got a right to know what records are kept against him, and that itself could affect that. I mean, that could come up on an enhanced criminal record check, for example.
I follow that, but what about the part of what's said on behalf of the respondents is that there is a huge amount of this sort of material, and huge huge numbers of incidents are recorded.
Yes.
And it's not practical, it's said, to look into them, and it's important that this data should be recorded. That's the case that's made for the respondents. And what do you say about, at the moment you're talking about the impact on an individual who comes to know about it, as Mr. Miller did?
Yes.
And what do you say about a situation in which the individual doesn't know about it?
Well, that would come up on an enhanced criminal record check, even if you knew about it, even if the person knew about it or not, of course.
Well, it might do or might not, depending on the decision that's made.
Yes, and
but what is your case on interference with regard to the situation where an individual is not approached or spoken to, or anything like that?
That would be an interference as well.
Because?
Because it could have a detriment. It could have a detriment to them, which in the long, which ultimately could result in an impact on his freedom of speech. But you see, what?
Sorry, Mr. Wise. Is it the deterrence effect that it would have on the freedom to express those opinions, whether he knows it's been recorded or not? The potentiality of it being recorded would mean people would be fearful of expressing those sorts of opinions.
Absolutely.
And might stop them. Is that your case?
Yes. Well, that's what. That's. I put it rather clumsily. That's what this Turkish case is saying.
Well, that's what the Turkish case says.
Yes.
But my lady asked you what your case was, and I just wanted to understand what your case is.
Yes, my mistake. Yes, of course. It's the potential as well. Yes. 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 So one has, and when one analyses in this way, it's important then to go beyond the individual. When one's challenging a policy, such as we are in the present case, or such as Article 301 in the Turkish Criminal Code, one has to look at the impact generally, rather than the impact on any individual. So it is, as my lady says, the possibility of an investigation. The real possibility, the real risk is, I think, is what paragraph 58 says. Yes, people who not even real risk, people who risk being directly affected, and that's the point. So somebody who has a record against them without even knowing about it has a risk of further investigation, obviously. And that itself.
What do you say the police should do then when they get a complaint?
Well, they should investigate it, my lord.
But how
that's what Sir William Macpherson said in the Lawrence report all those years ago, which is said to be the root of this policy.
Every complaint.
That's what Bill Macpherson said, certainly.
Is that really practical?
Well. That would then focus the police's mind on the amount and quality of information that it collects. It's no defence to say, well, we collect hundreds of thousands or millions or however much information. If the quality of that information is of very limited or no value.
Just taking it in stages. A call comes in. They have to record the call, presumably.
Yes.
How do you say they should record that call?
Well, they should record it. They obviously have to record that an allegation is made. And bear in mind there is a distinction here between an allegation being made and there having been a non-crime hate incident. That's an important distinction.
Indeed. So language, you say, matters as to how it's.
It certainly does.
Designated.
But then, which is I think the crux of my lord's question is what do the police do then? It's not for us to write the policy, of course, but if the police then investigated that complaint to determine whether it was a frivolous complaint or there was anything in it, and then made a decision as to whether it should be properly recorded as whether a low level or a higher level incident or whatever, then that would be certainly less objectionable.
But if, supposing the complainant rang up and complained and said, this is a hate crime,
Yes.
What are the police supposed to do?
Have to investigate it.
They have to write down this.
Yes, of course they'll have to write it down. But you see, what necessarily follows, that if there's an investigation into an allegation that's frivolous or ill-founded or just wrong for whatever reason, it would be either expunged from the record, or the record would presumably say an allegation was made and it was ill-founded or whatever.
If a complainant rings up and instead of saying it's a hate crime, gives the police a bit of information, the police, according to that, has to put it into some sort of category, presumably.
What it does is it forwards it to the local police.
No, just pause it out. I'm talking about recording in the first instance.
Yes, yes.
Call comes in.
Yes.
Some complaints are made by the individual.
Yeah.
The police person has to record that and put it into some sort of category, presumably.
I really don't know whether
Well,
they just record the fact that a complaint has been made.
Being practical about this, for the purposes of data and so on, the police need to categorise. Are you saying that the police shouldn't have categories of this nature?
All they're doing at this stage is recording the fact that a call's been made. That doesn't have to be categorised in any, apart from the fact that it's categorised as a call.
You would draw a distinction between a complaint and the recording of an incident.
Yeah, absolutely. Sorry, perhaps I didn't make my point clear. You see, the real dangers, I mean, one just has to step back from this. My lord, I think it was my lord who said a few moments ago, the police say, well, they've got vast amounts of this information, especially from that lady, a vast amounts of information. They couldn't possibly investigate it all. But that's the Stasi defence, isn't it? You know, the state collects masses of information about people without any proper consideration. And it's not extreme to use that example, because that is what Article 10 and Article 8 and other relevant provisions of the European Convention on Human Rights were formed to deal with. It's precisely that sort of abuse of information by the state. It's not good enough. We were still looking at the Turkish case. And it draws it back. We've seen the general provisions, and the court, as you would expect, draws it back towards the end of this section to the context, the interference with freedom of expression, the free formation of ideas, and so on. We're going to take the court firstly to paragraph 78. We've got two paragraphs, two sections sidelined on page 448. You'll see it, paragraph 78, the court came to its conclusion that Article 301 did violate Article 10 of the Convention, despite the provision not having been applied in this particular type of case for a considerable time.
This is about interference, not violence.
Yes, we're still on interference at the moment, my lady, yes. And again reiterated the risk element in the final sentence there at 78. Accordingly, the applicant was said to run the risk of being directly affected by the provision in question. That's despite the fact that it hadn't been used in this sort of way for a considerable time. You'll see in the narrative, interesting as it is, that this provision had been used among some very prominent writers, Turkish writers, in the past, and that had created an international furore. And then at paragraph 81, the court further observes that thoughts and opinions on public matters are of a vulnerable nature. Therefore, the very possibility of interference by the authorities or by private parties acting without proper control, or even without the support of the authorities, may impose a serious burden on the free formation of ideas and democratic debate, and having a chilling effect. I think that's the point my lady, Lady Justice Simler was making earlier about the very possibility of interference. So the very possibility of interference was sufficient. The threshold is that low. the fundamental right is that important that the threshold is set that low. And then drawing it back to the facts of that case at 82, you see the last few lines. The threat hanging over the applicant is real. In these circumstances, the court considers that there's been an interference with the exercise of the applicant's right of freedom of expression under Article 10. The court then goes on to deal with prescribed by law, which of course is the next issue that we come to deal with. I think we've made the point there that just to round up on interference. The point put shortly is the judge misdirected himself and came to a wrong conclusion as to whether there's an interference in this case. Misdirected himself in setting the threshold too high. Of course, we have to have an interference to get to the next stage of the process, and that is as to whether the interference is prescribed by law. Of course, Article 10.2 sets out, as the court knows, a number of ways in which the right of freedom of expression is qualified. And you'll see how the judge dealt with that. We say the judge correctly directed himself to the relevant law on this issue. In particular, the speech of Lord Sumption in Legality, albeit an Article 8 case, as Lord Sumption made clear, what he's saying there applies to all the qualified rights, including Article 10. And one of the important points that Lord Sumption makes is the question of foreseeability is a binary one. Either the measure has the quality of law or it doesn't. But nevertheless, we say the judge then approached the matter wrongly. The judgment, this part of the judgment is at paragraphs 196 to 210. What he does, he starts, the prescribed by law section of the judgment starts at paragraph 186. He then sets out the relevant law, and it's the application of that to the present case that starts at paragraph 196 and goes on to paragraph 210. And what he says, paragraph 197, 196, you see, he says, where a non-crime hate incident is recorded, it is in my judgment, whether such an incident is recorded, it is in my judgment sufficiently foreseeable to satisfy the Strasbourg test. If someone behaves in a way which carries a possibility that another person may subjectively conclude, etc., the court sees that. But just pause there for a moment and consider the logic of that. What's said that if somebody could reasonably predict that a person such as Mrs. B, acting on the outer margins of rationality, as he found, would react in a particular way. And it only has to be stated to show how frankly nonsensical that proposition is.
Isn't he saying that Mrs. B's, he found that Mrs. B's complaint should not have been recorded?
Yes. No, he didn't. No, he didn't. No, he specifically said it could be recorded. He said the police action was unlawful.
Right.
Operational part.
Yes.
Yes. Yes.
Sorry.
And that's the point. And that's one of the very curious things about the judge's judgment, if I may say so, because he is so strong with respect to the facts of this particular case, and which are on any reading fairly extraordinary. They would seem to be extraordinary, but we would hope they are commonplace. But and yet, nevertheless, said that crime hate incident. And this is where it becomes very, very strange indeed. Almost to the point of being bizarre, we would say. How can any citizen predict how somebody operating at the outer margins of rationality are going to react to some lawful expression that they make? It's simply ludicrous. He qualifies what he says at paragraph 203, where the judge says, but it seems to me that this approach does not exclude that there must be on the facts narrated by the complainant be some rational basis for concluding that there is a hate element. But again, that's entirely inconsistent with A, what he said before, and the policy itself. The policy doesn't require there to be any evidence of a hate element. In fact, it specifically says there doesn't have to be. And even if one can read into the policy that there has to be some kind of evaluation or even at a cursory level as to whether there's a hate element, there's nowhere in the procedure to do that because they're automatically recorded. They may subsequently be investigated, they may not. So we say that the judge was wrong in that respect as well. He goes on to justify that point, by the way, by what Mr. Williams said at paragraph 11. I think we've dealt with that on 2 or 3 times, the importation of common sense. It's rather instructive to consider that in the light of this case. There certainly wasn't any importation of common sense into the way in which the Humberside police dealt with my client's tweets. But can we... Sorry, the judge also says, in this is the part where, this is the Lady Justice Simler's point about paragraphs 1.2.4 and 1.2.5, so and I apologise for getting that wrong. It was very strange. It said 1.5. I think we've already dealt with that. That they don't deal with this issue adequately at all. This issue, in terms of jurisprudence, can we return? Is dealt with in the Turkish case again? Can I invite the court to pick that judgment up again, the Akram and Turkey case? And they deal very shortly with this at pages 449 over to 450. At paragraph 87, they reiterate the well-worn parameters of being prescribed by law. The national law must be formulated with sufficient precision to enable the person concerned, if need be, with appropriate legal advice to foresee to a degree reasonable in circumstances the consequences which the actions may entail. We see that in time after time in the cases, and that's the touchstone. Not absolute certainty, etc. While certainty is highly desirable, may entail excessive rigidity, of course. It's over the page that we see the important part for our purposes, and again the relevant paragraphs are sidelined, paragraph 93 through to 96. And what it says with respect to Article 301 of the Turkish Criminal Code, as interpreted by the judiciary, is too wide and vague, and thus the provision constitutes a continuing threat to the exercise of the right of freedom of expression. In other words, the wording of the provision does not enable individuals to regulate their conduct or foresee the consequences of their acts. And the court will see the rest of the rationale and then goes on. It there, 95, it therefore follows that Article 301 of the Criminal Code does not meet the quality of law required by the court's settled case law, since it's done except in broad terms due to the lack of terms resulting in a lack of foreseeability as to its effects. The foregoing consideration is sufficient to enable the court to conclude that the experience in question was not prescribed by law, accordingly a breach of Article 10. When we say the same logic applies in the present case. The wording of these provisions do not enable individuals to, picking it up and repeating the language of the court at 93, do not enable individuals to regulate their conduct or foresee the consequences of their acts. Nobody could foresee the consequence of what happened in the present case. And in those circumstances, these provisions don't have the quality of law because they're not foreseeable, because the consequences aren't sufficiently foreseeable. And of course, if they don't have the requisite quality of law, we don't even get to proportionality. That's what happened in the Turkish case, of course, which is why the matter curtailed as it did at paragraph 96. The interference in question was not prescribed by law. End of the case. The Article 10 is accordingly violated. We say exactly the same about this case.
Mr. Wise, if you're are you moving on to another topic?
No, if I can just make two more comments
Yes.
on this. I see the time, my lady. Just remind the court of what we said in our skeleton argument, paragraphs 47 and 48. And at 47, what we do, we set out some illustrative examples of that demonstrate the uncertainty of these provisions. So what we postulated there, for example, a submission by an academic professor of feminist philosophy to a public consultation expressing concerns about permitting trans women to use women's refuges to be recordable as hate incidents under HCOG. Plainly, that's by reference to Professor Stock. That's the root of that. She wouldn't have any idea at all whether somebody would take umbrage sufficient to make a complaint to the police, and that complaint would then be recorded as a non-crime hate incident. Simply impossible to foresee the consequences of writing an academic article by a professor. The second example that we give there is a High Court judgment. And we see that the example given was taken from the President of the Family Division judgment in the T case. Under these provisions, it's impossible to know whether a complaint would be made against the judge in that case. It's uncertain, and uncertainty, of course, is contrary to the rule of law. Especially given the concept of freedom of expression and the lack of any hostility in those particular contexts. And then we say at paragraph 48, lastly, that none of this undermines the importance of the approach that accords substantial importance to the perceptions of victim of a perceived hate incident. However, in making the perception the sole criterion of whether a hate incident occurred, and then at best simply leaving it to the officer's common sense, if that is in fact what happens, isn't sufficient. for the foreseeability criteria we've set out it from Sunday Times. It's set out in numerous cases. So that then, my ladies and my lord, is the foreseeability aspect of this case and why the judge got it wrong below. I only have the proportionality limb of my case to deal with, which I can deal with tomorrow morning, hopefully fairly shortly. I wouldn't imagine being more than a quarter of an hour, frankly, with that. Perhaps 20 minutes, but thereabouts. So we've made good progress. So if it's a convenient moment for my ladies and my lord.
Thank you very much. Sit again tomorrow at 10:30.
Court rise.